So welcome again, and thank you for joining us. We're going to talk about a piece of special education legislation that is intended to strengthen parent participation in the IEP process. And first thing I'd like to do is welcome and introduce our guests, Senator Ilana DiMario and Representative Rebecca Kislak, who have introduced this bill that we're going to talk about tonight in their respective chambers. In the Senate, it is Senate Bill 180. And House Bill 5772. I'll start with kind of quick explanation of what this bill aims to do to kind of change the IEP process, talk a little bit about the context, and then get into a little more detail about the bill, leaving plenty of time for you to ask your questions of Senator DiMario, Rep. Kislak, or myself. And you can, again, feel free to submit those questions at any time, and we will queue them up and have them ready to go. So this bill that we're going to talk about tonight, these bills would do three things. One is require written consent to change a student's IEP. The second is require that schools make available to parents certain documents before IEP meetings, any IEP meeting. And three, guarantee that parents have the right to observe proposed programs or placements for their kiddos before they give that consent. So why this legislation? What's the goal behind this? What's the purpose? If you have a child who has an IEP, receives special education services, you're probably very familiar with the process and with the concept of the IEP team. It's really meant to be a collaborative process where parents, educators, administrators, other service providers from the school all come together and work cooperatively to come up with an individualized plan or program for the student that meets the student's needs. This collaboration is really at the heart of the IDEA, and for the most part, it works really well. Sometimes, however, parents and schools disagree, even as you go through this process. And everybody can participate in good faith, understand where other sides are coming from, but still not come to the same conclusions about what's best for the student. So when parents and schools disagree, and when you have that first initial IEP, you need parental consent to start those special education services, get that first IEP off the ground. But after that, for subsequent IEPs, the school does not need to secure parental consent. So if you get to that point where there's a disagreement, then that can leave you as the parent in a situation where you have to now seek mediation, or you have to, as the parent, seek due process, which is a very burdensome process. It's due process. It's very expensive. It can be confusing and overwhelming. You really do need an attorney. Some parents do try to represent themselves, but that usually doesn't go very well. It's almost like going to court. So that's difficult, that can be your only recourse. So what does this legislation do? It tries to kind of shift that balance a little bit. And so going in order with the three pieces, we'll pick them apart one by one. First is requiring that written parental consent for a change to a student's IEP for those subsequent IEPs. So what's it look like? First of all, for a little bit of background, this was the law and was required in Rhode Island prior to 2008. Around 2004, the federal IDEA, that's the federal law that governs special education for the whole country, that was reauthorized in 2004. And part of that reauthorization kind of changed what the rules that some states could do around consent and the IEP process. So in 2008, because now we had this as an option, Rhode Island decided to drop that written parental consent for the IEP changes. Other states, however, kind of maintained it, and it is still the current law in most other states. We think it's about 25 to 30 states, our research has shown, has this, including Massachusetts and New Hampshire. So we're kind of the outlier in Rhode Island on this particular piece. How does it work? So you as the parent can agree in whole or in part to the IEP. You can, if there are pieces of it that you like and agree with, you can sign off on those. But then if there are pieces that you don't agree with or don't feel comfortable with, you cannot consent to those. Any piece that you don't sign off on or don't give your consent, there's no change. That is to say that the IEP in place stays in place. So if you, and I want to point out too, that if you disagree with one part of the IEP and don't sign off, the school cannot delay the implementation of the change that you have agreed to. So you can really like take it piece by piece. So you can agree in whole or in part. Anything you don't agree to stays the same. And at that point, the school has the option, they reserve the right, as they do now, to seek due process on their side, or mediation, or what have you, whatever next steps. They can do that, or of course, they can return to the IEP table and try to work out something with the parents. The schools are better resourced than most households, of course, when it comes to this due process, but they're also super reluctant, and they don't want to go to due process any more than a parent does. So what we think this will do is kind of shift the balance and level the playing field a little bit for parents when it comes to the IEP process and these changes. What if parents don't participate? This is a question we get a lot. So the school, they call the parent, they send emails, they don't respond, parents don't show up to the meetings. What happens then? Well, the school makes those attempts and they document them. And if a certain period of time elapses, 30 days perhaps, it's not really spelled out in the legislation, I don't think. The idea is that you can't let parental non-participation just stop the whole thing. So if a school makes those attempts and documents them, they can then move ahead without parent consent, only in those situations where the parents aren't participating at all. So if you're showing up, if you're engaged, if you're part of the process, then they can't move ahead without your written parental consent. So that's the first piece of written consent, kind of the biggest piece of this legislation. And the other two prongs are really meant to support that and make sure that that consent is informed. So another thing the bills would do is require that schools provide certain documents before IEP meetings. So we hear this a lot at RIPIN from parents. They show up to an IEP meeting and there's a lot of, maybe it's evaluation reports, maybe it's draft IEPs, maybe it's other reports or important documents that they get right at the beginning of the meeting. They haven't seen them before. IEP meetings usually like 45 minutes long, sometimes less. So that's really not enough time to adequately digest all that information and then make these very important, very critical decisions about your child's future and about your child's education. So the bill would require that schools provide those documents, any relevant documents, at least 7 days in advance of any IEP meeting. And that includes, like I said, evaluation reports, any draft IEPs, any other relevant documents. That can be waived if both the parents and the school agree. The idea being that you as a parent, you don't have to let this, or this 7-day advance requirement shouldn't totally mess up scheduling the IEP meeting. If you as the parent are comfortable waiving that, then you can, that doesn't have to be a delay. But at the same time, we do think it's important that parents have the opportunity to review some of this stuff ahead of time. So in addition to that, requiring documents, there's also this guarantee for a right to observe programs and placements that are proposed. Observe them before you've kind of agreed to them. This is something that a lot of districts might do right now and a lot of different schools. It's all on a case-by-case basis. So you might call up and ask, oh, my child's been recommended to this classroom, I'd like to go see it. And the school might be like, yes, no problem. Let you come in and observe for a couple hours. But it's totally at their discretion. And a lot of times parents don't get the opportunity to observe, and they don't get that request met. So just to make it consistent across the state, this bill would guarantee that all parents have the right to observe these placements prior to giving their consent. And of course, there would have to be some, it can't be a free-for-all. It would have to be some reasonable guardrails around that to protect the privacy of other students, to not overburden the school personnel, because any visitor to a school typically has to be escorted by a staff person the entire time we're there. We don't want to tie up somebody for an entire day. So there would be some reasonable regulations around this that would be developed. But we think it can work because, again, this is another thing they do in other states, including Massachusetts. In Massachusetts, they have found that parents have this right. So that's, again, to summarize what this legislation would do: require that written parental consent for any IEP changes, require that schools send those documents in advance before IEP meetings, and guarantee that parents have the right to observe proposed placements or programs before they give their consent. So this bill was introduced again by our sponsors who are on the call with us early in the session. What's the status of them now? They've both had their hearings in their respective chamber committees. Really good hearings. Lots of people came out in support. Lots of great questions from stakeholders and from the senators and representatives. In both cases, it was held for further study, which is the common practice. That's kind of how this works at this point. They hear and discuss the bills, and then they get held for further study. In the meantime, there's ongoing discussions between the sponsors, RIPIN, and other stakeholders who have a vested interest in this legislation were it to pass. So looking at who has come out to support it at those hearings, RIPIN, of course, a number of other organizations that advocate for parents and for families. PLEA in Providence submitted testimony in support. Kids Count, the Rhode Island Developmental Disabilities Council, and a number of individual parents came out. We collected testimony at RIPIN. We collected written testimony from about 36 parents total, and we had a number of parents show up in person at both committee hearings who came out and showed their support. Other stakeholders who are part of this, the Association of Rhode Island Administrators of Special Education, or ARISE. They pronounce it ARISE, even though it looks like REAs to me, but they have a lot of concerns about the bill, and we've been working with them throughout the process. To give you an example, 7 days prior, to provide those documents 7 days in advance, they think that would be difficult to meet. I'm sure that we can find a compromise between the legislators and ARISE. Maybe it's 5 days, maybe it's 2 days. That's all stuff that can be worked out, and it's part of the legislative process. The Rhode Island School Superintendents Association, we've also been in touch with as it would impact their membership, and of course the Rhode Island Department of Education, they would be impacted by it. And so we've been working with all of those stakeholders throughout the process. So parents, if you like this, if this is something that you think would be beneficial, how can you get involved? How can you help? Obviously, of course, you can contact your state legislators. Let them know that these bills, that you support them, and ask that they support them as well. Ask your peers to support these bills. If you work with your local advisory committee for special education, you meet with other parents who have students who receive special education, ask them to contact their legislators and show their support. You can also sign up for updates from RIPIN, and in a moment I'll drop in the chat a link to where you can get email updates on this bill, other ways you can get involved, and other special education policy that RIPIN is following. And let's take a look at that actually real quick. Some other special education policy that's been proposed or that's been out there this year. First is the Special Education Ombudsman. This also had a hearing in the House. It hasn't had its hearing in the Senate yet. This bill's been introduced for a number of years. In the past, RIPIN had concerns about it, but we've been working with the sponsors. They've been great and have met a lot of those, have addressed a lot of those concerns in this year's version of the bill. So RIPIN supports this. We also we support a bill from, this is Representative Courtburn, I believe, a bill that would require that schools do a little bit more to put out information and support around the special education local advisory committees. This is actually going to be, I think, voted on in the House pretty soon. So that's pretty exciting. That's moving forward. Facilitated IEP, this isn't actually a bill or even a specific policy proposal at this point. It's kind of an idea that RIPIN definitely supports conceptually. Of course, we'd have to look at the details of any specific legislation or proposal. The idea with a facilitated IEP is that you have a facilitator who gets involved rather than waiting until there's a disagreement and going to mediation and having a mediator. You have a facilitator who's completely neutral, independent, not part of the school, not part of any, not part of RIDE, and they're just there to facilitate the conversation between the school personnel and the parents and all the members of the IEP team. They do this in a lot of other states. It's very, very successful. Requires some resources because you have to hire and pay and support these facilitators, but it's a great way to catch a lot of these issues kind of upstream in the process before they become major disagreements down the line. That's my spiel, and I'd like to turn it over now to Senator DeMario or Representative Kislak, whoever wants to go first. If either of you want to give your remarks or your thoughts on the bill, and then, of course, we'll take questions from the audience, and I can see some of them coming in now. Senator, would you like to go ahead?
Sure. Yeah, absolutely. And I want to make sure we leave plenty of time for questions as well. Thank you for that great overview of the bill, and thank you for all of your work that RIPIN has done to put this together, because I think, especially based on the testimony that we received in the Senate hearing, this is really something that parents want and feel like would really be beneficial to the system. And I think, you touched on this in your remarks, but I think what really came through in the hearing is the idea that a lot of these things are best practices that many school districts are doing because they believe it's best practice, and they have the resources and the capability to do that. And so I think this is really important, just to make sure that every student and every family has that opportunity. And, I come at this from the perspective, not only as a legislator, but also as a parent of a student who receives special education services. And I've been involved in the process from that angle. And I'm also an outpatient therapist who works with children and families, who has been involved in this process from my perspective as a professional as well. And, I think that there are so many opportunities to strengthen this process by making these small tweaks, because, as you mentioned, ideally, parents and educators are partners in this process. And, I do want to emphasize that, in no way are we trying to say that, parents should override the educational decisions of a trained educator, but more that, with increased involvement and with increased information, we can better do our job as parents to support our children, for example, through a transition to a new educational setting. If I, as a parent, have visited that setting and can describe to my child, this is what it's going to look like, I met your teacher, this is what it's going to be like, launching my child off on that first day into that new educational setting is going to make for a much more successful day. And so, I think that there's just a really important component here to me about emphasizing that idea of partnership. And I do also just, really want to reiterate that I think that special educators are, do the best that they can with the resources that they have. And I think that there is a component of this conversation as well, where we just also need to make sure that we are giving our schools the resources that they need to be able to do these things and implement them appropriately. And that's something that I'm committed to continuing to work on as well. So I'm going to hand it over to Rep Kislak to talk about maybe her experience. I do also just want to say that in the Senate Education Committee had a lot of positive feedback on this bill. And in fact, a number of the members of the committee asked to sign on as co-sponsors following the hearing. So they're very eager to continue to work to make those tweaks and incorporate some of that testimony to see how we can move this forward this year. So thank you.
Thank you. That's great to hear. And jumping off of Senator DeMario's comments, I would maybe add one more bill to the list, because our schools being under-resourced is a huge and generational problem in Rhode Island. And we keep modeling education efforts after Massachusetts, but one big difference is that Massachusetts has a constitutional right to an education. And with that right comes the funding that's required to make that a reality. And so we have for many years, I don't remember if the Senate has been passing this. I think you have been. And it's been stuck in the House. There are over 50 sponsors to a bill that would put on the ballot a constitutional right to an education here in Rhode Island. And I think that that's really important in terms of making sure our schools have the resources to do what they need to do in order to really support all of our children and make sure they all get the free and appropriate education and a good constitutionally required education. So I am hopeful that we can move on a lot of education things this year. And this bill, I think, is one really important piece that could make people's lives a little easier, make families' lives easier. So I'm really hoping that we can move forward and sort of change the expectations about what we as families can expect from an IEP or special ed process, so that we know more going into it. So I love this. I I testified, or when I was introducing the bill, I said that I have practiced minimal law around special ed law, but I used to practice in Massachusetts and now I practice in Rhode Island. And the differences in terms of having notices before going to meetings is significant and really important. So I'm starting to, I will turn it back over soon to Mark to go through the Q&A, but as I'm looking at it, I see somebody asked about her discomfort as a parent in having somebody observe her child's classroom. And I just want to share a story from another parent who spoke to me at the State House about how really important it was that she observed the classroom, but I'm not sure it was necessarily important that she observed it during teaching, although it often is. But this is a parent who went into the classroom and took pictures for her child before her child started so that they could make the child ready to go to the classroom. And I thought that was really significant and important too. So I think for a lot of this, there's a lot of two-way communication that I hope this bill and more things that we need to do can help facilitate the communication that schools and families really need to be able to have in order for kids to thrive. So thank you.
Thank you. That's very well said. And yeah, it's kind of, there's a lot of issues with special education. RIPIN, of course, we are very much aware of the parents who call us and some of the things that they encounter. The amount of activity at the State House, I feel like in the last couple of years, and this year in particular, trying to address some of these problems, it's been heartening to see the level of awareness and some of the efforts that the legislators are making. So one question, is there a Senate sister bill for House Bill 5668? That's the... Yes. Okay.
Yes.
I couldn't find it.
Yes, it's mine. That's how I know.
Oh,
So
easy.
It is Senate Bill number 489. It has not had a hearing yet on the Senate side. But yes, it is Senate Bill 489, and I'm the lead sponsor for that one. Representative Cortfriend had reached out and asked me to partner with her on that one. So.
I talked about it very briefly. Do you want to say maybe a few more words about what that bill aims to do?
Sure. So, I mean, I think your explanation of it kind of covers it pretty well. But I think that the idea behind it is just, the more information there is about this opportunity that exists for input, the more we're going to be able to draw from a wider pool of people who could potentially participate in that process, and that will ultimately strengthen the process. So, I think that's kind of where that came from. But Rep. Cortfriend has definitely taken the lead on that one. So, and I also did just want to loop back because I saw another question come in. I want to be clear. I think, somebody had mentioned something about, pictures being concerning. I want to be really clear. Nobody's going to be taking photographs of other children in an educational setting. So, I've also had the experience working with a client family where, there was a child who, and actually I shared this information in my bill introduction with permission from the family, that, there was a child I was working with, and this child had a lot of anxiety around using the bathroom in new places. And so the parent, when this child changed their educational setting, the parent was able to go and look around this setting outside of school hours. There was no other children there at all. And this parent was then able to take pictures of, this is what your classroom looks like. This is what the bathroom looks like. This is what the nurse's office looks like. And, and really reduce a lot of the anxiety for their child about going into that new setting. But certainly, there are a lot of privacy concerns, and that, that would not be something that would be a regular practice, taking pictures of classrooms, or even having necessarily parents going there during school hours. So that, I think that's the other thing to flag that came up during that conversation.
Yes, thank you very much. There's definitely a lot of details that would have to be kind of worked out if this were enacted. And, sometimes legislation, it doesn't get that granular. But right. It's certainly never the intent to, we think we can make it work and respect all parties involved. So another question, as a parent going through due process, things can go sideways very fast. Will there be more support during this process, presumably during the due process? Not in this legislation that we're talking about today, this bill that we're focusing on. I know that in other states, that legal support, I think, is more readily available. And correct me if I'm wrong, but I think it sometimes is provided at no cost to parents. I don't know if that's accurate, but yeah, it's something that we hear about a lot at RIPIN. When you go to due process, it becomes very formal, it becomes very legal. One thing I was reading recently, the way they framed it, it was like at that point, it stops being about the child and what's best for the child and starts getting to be about the laws and the regulations and the rules and who can prove their case, and who has that burden of proof. So there's definitely a need. I'll say I acknowledge that there's definitely a need for more support during that process. This bill in and of itself wouldn't really address that, but it's something that I think a lot of folks are looking at. Okay, here's a question about where are you on the negotiations for the time period for the documents? Senate committee wants us to go above what Massachusetts has, which is 48 hours. Are we looking at 72 hours? I don't know any specifics. I'm not sure if Senator DeMario or Representative Kislak have something to share on that, but I think that it is an achievable kind of compromise. It's been really great, folks who have voiced concerns, they have been reasonable concerns, and they've been reasonable things that we can work together on. Sorry, go ahead, Senator.
No, I would agree exactly with what you're saying. I think that there is a consensus point that we can come to. I also do know that some of the discussion has been around differentiating what types of documents might be available ahead of time or further ahead of time versus not, because there could be some things, for example, around like observations of classroom behavior or, those types of things that might be more proximal to the meeting and therefore might not necessarily be available versus something like the results of a formal evaluation that, would be able to be prepared more in advance of the meeting. So that's kind of the nature of the discussion that's been going on the Senate side. And we'll kind of continue to take in that, the different testimony and figure out what the right kind of balance is. I also just think that, candidly, from my perspective, I think that if we can implement something that gets information in the hands of parents before the meeting, and that turns out and we get that happening on the ground, and that turns out to not be enough time, we can then take that back in and adjust it. But, I think that there's value in the idea of implementing some type of advance notice requirement and getting that going and then evaluating how it's working out in practice and tweaking as needed.
Yeah, and I am really aware that it used to be easier, and it may still be easier in other states, but I think it became much harder in general after 2004, I think you said, is when the legislation around special education was updated. And I remember it becoming more difficult for folks to find attorneys because attorneys' fees used to be available to families who were successful in the due process. And those are not available anymore. And it has made finding attorneys who will represent you for an affordable amount or for free nearly impossible unless you're eligible for legal services and fit in their prioritization. So I think that anything that gets families what they need before going through due process is great. I also think giving families even 2 or 3 or 4 or 7 days, we were talking about it's probably not going to be 7 days, but whatever it is, that means that families have documents in their hands. They can read them and see what they understand and what they don't, but equally importantly, they may be able to not have a lawyer, but have a lawyer who will talk to them, but not represent them. And they may be able to get some legal advice and preparation for going into the hearing or the meeting without a lawyer. And so I think 2 or 3 days is enough time for folks to be able to do that if we can make sure that that resource is around.
Excellent, thank you. Another question, can you explain more about what the pros and cons are to a constitutional education, to a constitutional right to an education? And they also ask, what is the bill number?
So I can answer. The bill number on the Senate side is 72. It's sponsored by Senator Picard, and it did already actually pass the Senate again this year. And just to be clear too, the bill is actually, because it would be a constitutional change, what the bill does is it actually puts a question on the ballot for the voters of Rhode Island to decide whether or not to amend the Constitution to make education a constitutional right. So this wouldn't be the final word. The final word would be decided by the people of Rhode Island. And so in my opinion, and Rep. Kislak touched on this a little bit, and I'm sure she can add more to this, but in my mind, the pros are that then, we are committing to achieving a certain level of educational commitment for each of Rhode Island's children. And the cons is that then which I think is also a pro, we're committed as a state then to providing the resources necessary to do that, but it'll cost them money. So Rep. Kislak, if you want to add that, your perspective.
Right. Yeah, I 100% agree with everything that Senator DeMario just said. I put the text of the bill with the House number in the Q&A answered chat box. It's 5771, and it's introduced by Representative Messier. And the current case law says that the children of Rhode Island have the right to whatever education the General Assembly sees fit to provide. There's a court case that says that. That's pretty close to word for word, I think. And I think it's incredibly insufficient. And so it does mean that families will have the right to sue if they don't get an appropriate education for their child. And this is not just the federal right to free and appropriate education. This is the children of Pawtucket are not, because it was a Pawtucket court case a dozen or more years ago, that is the one that found that kids in Rhode Island don't have a constitutional right to an education. It's that they're just not getting enough of an education and not being prepared for the world. And so it's a higher, or it applies more broadly than the special education laws for free and appropriate education, and will help a lot of kids in, frankly, all of our school districts, but especially the ones who are further behind.
Great, thank you. One question here. What are your thoughts on the 60-day time period for evaluations being cut short by 7 days? Would this bill possibly lengthen that 60-day time frame? So the idea that if it has to be provided 7 days in advance, that you're then cutting into the 60-day evaluation period. I don't know if either of you want to speak to that. I don't think that that's really the intent, is to tighten turnaround times on anything.
And well, can I just add a question to that for Senator DeMario? And we haven't had this conversation, but I imagine that some of your clients, I don't know if you do testing, but I'm certain that you work with some clients who are also privately evaluated or evaluated through school systems. I think we have a backup in the system in general, and it's throughout education and also the healthcare system, that there just aren't adequate folks available to test people. And so what happens when you can't get in for 6 months for a private evaluation? How can we expect Providence schools to do it more quickly if they have fewer people trained to do evaluations than they did before? And so I think that's a bigger problem that our systems have. So I just want to throw that, but it's not specific to this legislation, and I'm not concerned about 7 days or 3 days or whatever we end up being really changing the calculus, because there's such bigger problems.
Yeah, and I would need to take a look to, I mean, I think that is something to keep in mind is, you know, if with the 60-day time frame, is the 60-day deadline the deadline for which the evaluation needs to be completed, but not necessarily the day, like by the 60th day, that's not necessarily the day that the meeting would be held, if I'm remembering correctly. I don't mean just put you on the spot there, Mark, but I guess I'm just trying to think about the progression, right? So like when you initiate the request, that then does have, you know, those time periods associated with it.
Yes.
But the completion of the evaluation by that 60th day doesn't necessarily indicate then that on that 60th day, the IEP meeting is going to be taking place.
Well, I don't want to say the wrong thing.
Okay. So maybe we should just say that we need to clarify that to make sure we're not artificial, you know, unnecessarily tightening that deadline.
It's a concern that's been raised around, you know, there are a lot of deadlines, there are a lot of tight turnaround times.
Yeah.
I want to read one comment that just came in because it's relevant to this. They write, staffing is an issue, but we always work to meet our timelines as best as we can. Not having the full 60 days is a big deal. It is calendar days, not school days. So I think that this legislation is, we're going through these conversations, and you sponsors are going through the conversations with different stakeholders. And this is probably something that we could try to address and clarify, because I don't think it's anyone's intent to, you know, make things harder or unnecessarily or artificially shorten timelines, especially when, as you pointed out, and as this commenter points out, it's hard. It's a lack of staffing and a lack of resources.
And along those lines too, I think, you know, and there are tons of different associated bills on these different things, but, you know, we are also working on things like getting state funding for school psychologists to make sure that schools that are under-resourced in that area have the support to be able to have the staff that they need. You know, we're also, again, trying to make sure that as we're trying to make these changes, we're giving the additional supports that are necessary in order to achieve those goals. And again, it's, you know, I think it's the important part is looking at that idea of what the potential benefit of advance notice could be. And if then we need to look at what that means in terms of, you know, those other timelines to be able to achieve that, then that, you know, that's certainly something that we should be talking about in these discussions.
Excellent, thank you. So next question / comment, they write, I am also concerned to be able to pick and choose services for my son. I feel like schools are the experts, and this could really hinder progress for some students. For example, if I disagreed that my son be pulled out of class for OT, that could really hinder his progress to regulate his emotions and be attentive in class. I don't know if either of you want to speak to that. I would summarize it as kind of the general concern that if this bill were to pass and you have this parental consent requirement, that some parents are going to use that would ultimately be used to the detriment of the child. And I think a big part of this is kind of operating under an assumption that everyone's working in the best interest of the child. But I don't know if either of you would like to speak to that or comment on that.
I just want to say it's all about balancing. And I think that there is a real, in many school districts and for many kids and families, this assumption on the part of the school that the school is the only, those are the important people on the IEP team, and they are there to tell the parents what they are going to do. Other school districts or classrooms or teams see the parents and sometimes the kids, if they're older, as real and collaborative and equal members of the teams, but that's not universal. And so I think it's all about fostering good communication And nothing is going to be perfect in the balancing. And I did hear that concern when I was first talking about this bill with some of my colleagues about how parents are going to pretend to be educators, which some of us are, but most of us aren't, and not listen to the schools. And that's a problem too. So yeah, that's a problem. And this is a rebalancing, I think, that is fair. And that reminds the teams that families do need to be included.
Thank you. Senator Mara, do you have anything to add?
No, I mean, again, I think that it is, that also was a concern of mine as well, is that idea that, you know, the intent of this bill is not to undermine or override the expertise of the educators, but more just to make sure that the parents are understanding the changes that are being made, understanding what's being implemented. And I think that's, you know, specifically with the idea of, you know, changes to services, balancing out where a lot of the testimony that we've also heard is parents that feel like services were taken away too soon or were reduced before they thought that, you know, they were needed, and kind of being able to kind of get on board with that, you know, balancing out that need with, you know, this potential need, and hoping, as Rep. Kislak mentioned, that partnership can exist to the extent that, you know, the educators would be able to work with the parents to understand, you know, why it is that that change might be necessary, and you know, what type of compromise might be able to exist. So if the concern is, well, my child's going to be too anxious about continually missing their math class in order to pull out OT, like, okay, well, is there another, you know, is there another spot in their schedule that would make more sense then, that the child would have less anxiety about, et cetera. So, but I definitely hear that concern, and I understand.
Thank you. Thank you. Next question. I'm concerned about the burden now being on the district side to bring the parent to mediation and due process, which will cost the parents still in the end. Will there be guidance on steps that need to be taken first, similar to Cadre's infographic that David Zienko from RIDE spoke about at another meeting that some of these parents on the webinar were at? So I'll kind of try to summarize this. There's this concern that what's going to happen is parents don't consent, and that just means that schools initiate due process. You know, I think that I'll just say briefly and then let you speak. I think that this is not likely to really increase due process. I think that the schools don't want to take parents to due process. It's burdensome for them as well. And I think the idea is that they would rather go back and work with the parents in the IEP context. But I'll let Rebecca or Alana kind of add to that.
Yeah, I mean, yes, I don't have that much to add. I just think that we need to keep rebalancing and keep the lines of communication open. And the more I think and talk about all of this, it really is a resource issue as much as anything else. And if we were able to properly resource our schools and our special education programs, then it wouldn't be quite the same kind of burden on any part of the system.
Thank you. Finally, with IDEA allowing, this is more of a comment, with IDEA allowing schools to consolidate referral and IEP meetings, which is something Rhode Island does, they write, I appreciate the idea of documentation being available before those meetings. It is overwhelming to digest new information while writing an IEP simultaneously. This commenter refers to the fact that in the past, I believe you couldn't mash up those meetings, that referral and that IEP meeting. They had to be separate. And so you had the referral and you got that evaluation, you got a lot of information ahead of time and could digest it before you start making the plan that the school is going to adhere to for the next year. Now that those meetings are consolidated, which there's obvious benefits to that approach as well, one way to address that would be what we're talking about here, would be providing those documents in advance. So thank you for that comment. That is something we are trying to work on. Another comment, this is not what we are experiencing from our district. They are forcing parents to file. I'm not sure what district this person's referring to. I think that, the school, I think what we're trying to do, you hear this phrase a lot, is level the playing field. We work with parents at RIPIN who come to us feeling like, and again, most of the time, these IEP process, the IEP team works together great. It's a collaborative process where everybody is, mutually supportive, and everyone is supportive ultimately of the child in question at the end of the day. Sometimes though, parents feel like they're not heard. They feel like they don't have any recourse other than these very, difficult processes for them to have to initiate. And so the goal here really is to level the playing field, give parents just a little bit more, feel a little bit more empowered, and really feel like they're more meaningful participants in the process. That's all I have to say about that. If either of you want to add anything, but I think that's what we're trying to do. And another question with the consolidation that you speak of. So I think referring to the consolidation of the referral meeting and the IEP meeting. We need to allow more time for meetings to make them more meaningful and productive. Parents are taking time off from work, and 45 minutes for a meeting is not enough time in certain situations. Can we address this?
Right. And I think like at my kids' school, they have IEP meetings only on Wednesdays, and they schedule them 45 minutes all day every Wednesday. And that's just how they're able to get the team together. So I don't know what the answer is to that issue and how to make that happen, except again, it's a resource issue and we don't have enough folks at our schools to be taking care of and educating our kids. And that's a money thing.
Yeah, absolutely. It is a lot to have to try to get through in 45 minutes. A colleague at RIPIN the other day relayed a story about an IEP meeting that was 30 minutes. And it again involved a long report and a lot of information to take in. And so half an hour,
Right.
and these are big decisions.
Right. And in the 30 minutes, I really think that this is the kind of thing that building a team is really important, and building trust and a rapport is really important. And I think some of the parental experience of school, of coming into a meeting and school saying, here's what we're going to do for your kid, works really well if you say, thank you very much, I appreciate it, goodbye. But it doesn't work really well if you have questions or concerns, or you need to trust the people who are telling you this, but you don't have a relationship with them, and you can't build that kind of relationship in a 45-minute meeting, for sure.
Another question back to the constitutional right to an education. So adding the right to an education to the Rhode Island Constitution would allow more money to fund our school?
It would, because people would sue for the violation of that right. And then instead of the General Assembly making the budget for the schools, and the General Assembly plus the cities and towns, if a particular school district was underfunded in a way that it violated the right to an education, then a court would direct the funders to go back and rewrite the budget. So yes.
Thank you for that answer. No other questions at the moment. I think we'll begin to wrap up. Oh, here we go. This is against IDEA to limit the meeting. The meeting must be as long as necessary, not 30 or 45 minutes. Money is not allowed as a limit.
Yeah, there's a lot. So before I was a legislator, where the budget is actually a part of my responsibility, as an advocate, I would go into meetings and say, not my problem where the money is coming from. My kid or this kid who I'm representing has this right now, go figure it out. So you're absolutely right. If there is a need for a special education service or a need for a particular evaluation or a need for a 2-hour meeting about a particular kid with the team, those are all rights that they have that are also constrained by the fact that we're all human beings who need to sleep and need to eat and need to go home at the end of the day, whenever that might be. And so if a school needs to do, 20 IEP meetings in a week or 2 days or whatever, then they are constrained by the fact that it's human beings doing this.
Thank you. One question now for Senator DeMario, Rep. Kislak. Do you have any takeaways from this to make any changes to the bill as it is written?
I mean, I think definitely the comments here reinforce a lot of the testimony that we received in the Senate hearing, at least, especially around the concerns about privacy issues with potential observation of a new educational setting. That is something that, we want to make sure is spelled out in the bill to address those concerns. I did also want to say, and I think you would allude to this earlier, Mark, but that privacy laws that exist will still exist whether or not they're specifically referenced in this bill. You know what I mean? So that there are certain things that this bill would not override that, but definitely around the idea of concerns for privacy with the observations. And then, taking a look at what is the right balance between notice ahead of time with that documentation versus, what the kind of on the ground realities are about getting that information out and finding the right balance between the two.
Thank you. Rep. Kislak, did you have any additional takeaways to share?
Just it's really important, and I'm not sure that I remember a time where our special education system was adequately funded and worked swimmingly, but it feels like it's really bad right now. And so I hope that we can start moving in a better direction to support kids and families better.
Thank you. Thanks. Yes. And like I said, there is a lot of activity around this and a lot of work to be done. We're very grateful to everyone in the General Assembly who's taking time and taking their resources and putting attention on these issues. And super grateful to you both, Senator DeMario, Representative Kislak, for your work, for sponsoring these bills, and for taking the time with us this evening to answer some folks' questions. Thank you so much for joining us.
Thank you. Have a great night.
Thank you
so
all.
much. Appreciate
Thank you all
it.
for coming. Enjoy the rest of your evening and take care.
Thanks, you too.